Hi, I'm Tim Naftali. I'm director of the Richard Nixon Presidential Library Museum in Yorba Linda, California. It's October 1st, 2011. We're in New York City, and I have the honor and privilege to be interviewing Bernie Nussbaum for the Richard Nixon Oral History Program. Bernie, thank you for doing this.
Glad to be here.
So to help the viewer understand 1974 and you, let's go back and tell us, please, a little bit about how you became a lawyer.
I was born in 1937. So I was 37 years old in 1974. I was born in Manhattan, on the Lower East Side of Manhattan. My parents were immigrants. They were the first in their family to come to the United States. They met and married here, but they were born in Poland, and I was the first child born in the United States. I grew up on the Lower East Side, which was primarily a poor neighborhood, populated by Jews and others, and at the time, and it was a very modest but very warm and loving upbringing. I went to New York City public schools. I was educated in public schools. I entered public school in 1942. I graduated from Stuyvesant High School in 1954, and then I went from there with honors, actually, and then I went from there to Columbia College. I got a scholarship, and I went to Columbia College. I was the first in my family to attend college. I went to Columbia College, where I did well. I became editor-in-chief of the Columbia Daily Spectator, which was the college daily newspaper, and I was Phi Beta Kappa. And then I went to Harvard Law School. I got into Harvard Law School, and I did pretty well in Harvard Law School also. I made the Law Review, and I was note editor of the Law Review. A year after at the end of law school, at the end of my third year in law school, my contemporaries in law school were Anthony Kennedy, who was now in the Supreme Court, who was in my class, and Nino Scalia, with whom I served with on the Law Review. So I knew these people a long time ago at that time. After law school, I didn't clerk, but I received an award called the Harvard University Sheldon Traveling Fellowship, and I traveled around the world for a year. I traveled to 30 countries. I was 24 years old at the time. I came back to the United States at the age of 25. I decided I want to be a trial lawyer, so I applied to the U.S. Attorney's Office. Actually, I applied before I left. And there was a new U.S. Attorney, John Kennedy, just been elected president a short time before. The new U.S. Attorney was Robert Morgenthau, and he interviewed me as well as other people on the staff, and he offered me a job as an assistant U.S. attorney. It was unusual to be able to get a job right out of law school, but the office was sort of turning over at that time, and I managed to do it. So I was 25 years old when I obtained that job, when I got that job. And I started it when I returned from this trip around the world. I went to 30 different countries. And I started that in 1962. And I worked in the U.S. Attorney's Office from 1962 to 1966, prosecuting criminal cases. I took 6 months out to serve in the United States Army Reserves, which I did during that period. And I got to know Morgenthau fairly well. Obviously, he was my boss at the time. And it was a great office. It was an office of prosecutors, and you really learned to try cases in that office, and to deal with judges, and to deal with juries, and to deal with factual presentations and factual gathering and investigations. I left the U.S. Attorney's Office in 1966 and joined a firm which a friend of mine was involved in starting. It's a firm called Wachtell, Lipton, Rosen, Katz, and Kern at the time. It was 8 lawyers at the time. I joined that in 1966. That firm has now grown. It's a very successful firm. And I've been with actually that firm for 45 years, from 1966 till today, other than leaving on a couple of occasions, one of which was Watergate, and the other one was to go to the White House in 1992, 1993. So I joined that firm, and I became a lawyer at Wachtell Lipton, and I became a private practitioner, and I spent time with my other partners. I came as an associate. I became a partner 2 years later, building the practice that we now enjoy. I was active politically to some extent. I ran for office, actually, in 1968. I ran for the State Assembly in 1968 in a primary in Brooklyn, where I lived at the time. Fortunately, I lost, so that I could move to the suburbs with my wife and my children. I ended up having, with my wife, 3 children. and I moved to Scarsdale, New York at that time. And so I was involved in the Morgenthau campaign. Actually, Morgenthau ran for governor in 1970, and I was his campaign manager in 1970. And I met Elizabeth. Elizabeth Holtzman had worked, a woman named Elizabeth, worked in Wachtell Lipton for a short time. When I came to Wachtell Lipton, she was there for a short time. So that's how I met her. She then left Wachtell Lipton and went into the government to work for John Lindsay. And then she went into politics. She left the government to go into politics. And she ran, I think it was in 1970, yes, it was 1970, for state committee woman, which is sort of a party position in Brooklyn. And she was attacked legally, claiming she didn't really live in Brooklyn. Her parents lived in Brooklyn. She didn't live in Brooklyn. And she asked me to represent her in that case. And I did represent her in that case. And we prevailed. We showed that she spent a great deal of time in Brooklyn. Her parents testified and all sorts of issues. But we won that case in 1970. So she was sort of solidified in politics. And I tried it in the Brooklyn courts. I was the trial lawyer in that case. And then 2 years later, this is all related actually to Watergate and the impeachment, obviously, in some respect. 2 years later, she decided to run for Congress. She ran for Congress against a long-term congressman named Emanuel Seller, who'd been in Congress for many years, 30 years, 35 years. Very powerful figure in Brooklyn and in Congress. He was the chairman of the House Judiciary Committee. Nobody thought she had a chance at that time. Even I didn't think she had a chance. She told me she was running. But she ran, and she won by 600 votes against Seller in a primary. It was a big surprise. The Brooklyn organization and Seller then brought a lawsuit against her to set aside the election and asking for a new election, claiming she stole the election, there was fraud, people voted or shouldn't have voted, all ridiculous charges. I mean, the Brooklyn organization controlled the electoral process, and she was an outsider who just happened to pull it off by campaigning very hard and being very attractive. So she asked me to represent her again. I was so reluctant to do it. I had a summer vacation planned. This takes place during the summer. My wife wasn't too happy about this. We took a cabin in Maine, which I never got to. But I did represent her, and in a very tough fight, we won. We won in the Brooklyn courts, which was, people didn't think we would do it, but we did win. And then we won in the appellate division, and then went to the Court of Appeals, and we won in the Court of Appeals. So we sustained her victory at that time, which I'm very proud of, and she was very happy about. That had an interesting impact that we didn't know in 1972, but we know now looking back. Because she won and went to Congress, Seller, of course, wasn't in Congress, which meant he had to step down as chairman of the House Judiciary Committee. He was no longer in Congress. And a new chairman was appointed, and that was Peter Rodino. And Peter Rodino, of course, ultimately became chairman during the impeachment proceedings involving Richard Nixon. And he performed enormously well. I mean, I'm sure in these interviews you'll hear about Rodino. He just died a few years ago. He lived well into his 90s, but he had he had the right temperament. Even though he had been attacked as a party hack and things like that, he really performed at a very high level. We wondered. No one can tell for sure how Seller would have performed, but Seller was a very partisan person. You know, he comes from the Brooklyn organization. He was an able guy in many ways, and I don't want to deprecate Seller, but I think it would have been a different impeachment proceeding looking back, and most people who were there, who know more than me, also think. So that in a funny way, although I ultimately was involved in the impeachment proceedings, what I did 2 years before, what Elizabeth Holtzman did 2 years before, probably had as greater impact in the impeachment proceeding as anything we did in 1974. Holtzman turned out as a congresswoman to be on the House Judiciary Committee, and she was there, and she was part of the impeachment proceedings, and an important part of the impeachment proceedings. But I think her victory 2 years before, and my sustaining of that victory as a lawyer, had probably a greater impact than whatever she did or I did 2 years later when we were part of it.
You're being a bit modest. There's a little courtroom drama in your victory 2 years before.
Oh.
It's a great story, though.
Well, there was a lot of courtroom drama in that one. No, the Brooklyn organization really wanted to win that case, and there was and one of the judge was a judge named Dominic Rinaldi, who was an old-time judge who came up through the organization, which most of the judges did at that time, And what I did in that case was, I knew it would be tough to win below in the trial court. I was hopeful I would win in the appellate court, so I lost the trial court. So what I ended up doing with people from my firm who assisted me on the case was to submit a brief to him at the beginning of the trial, a very lengthy brief, sort of summarizing all the law, and which really showed how really judges shouldn't upset elections except in the most unusual circumstances. And I really told the judge in the beginning of the trial, this is the brief I'm going to submit to the Court of Appeals. So, you know, I said it in a nice way, and I got on with the judge, because it's my job as a trial lawyer to try to get on with the judge. And so I really showed him that, you know, that I was going to take this all the way. That wasn't a surprise, but exactly what I was going to say to the Court of Appeals. And then we started trying the case, and of course, the organization had very good lawyers, actually. They really fought very hard in this case. The lawyer who opposed me in this case ultimately became a judge, which is not surprising. But he was a very good lawyer. So it was a hard fight. But I was fighting back very hard. They were accusing us of fraud and things like that, which was ridiculous. We were the outsiders. We were the reformers. And at one point I said to demonstrate that we had no control over any processes at all, I'm going to call Meade Esposito, the chairman of the Brooklyn organization. The whole courtroom started shaking. Everybody in that courtroom, one way or another, had gotten his job through Esposito. They all started like screaming, basically. So I withdrew I was getting along with some of them at this point. So I withdrew my request to subpoena Meade Esposito. And then, surprisingly, the judge below, Justice Rinaldi, ruled in our favor. And then when I argued the appellate division, his law secretary came to watch me argue and told me the judge had just been the subject of an article in the Village Voice, I guess it was, by Jack Newfield, listing the 10 worst judges in New York, and they listed Rinaldi first. And he asked me if I saw that article, and I said I did. And I thought it was a terrible thing. I thought the judge was fine. Obviously, I'd won this case now. And I thought he was fine. He really tried a good case. And he said, well, the judge, he says, well, I'm glad you think that. The judge thinks that too. He thinks this is a very bad article, and he would like to sue the Village Voice for libel, and he would like you to represent him. It's one of the biggest compliments I've gotten as a lawyer, the judge asking me to represent him. I backed out. I said, I can't do that. I still feel guilty about that to this day. The judge did get a lawyer, and they did sue for libel, and the case went to the Court of Appeals, and the Court of Appeals ultimately determined, not that there was immunity, that the Village Voice, you know, the judge lost, in effect, in the Court of Appeals' libel suit. But it was a very interesting byplay, that case. But the point is, in terms of Watergate, in terms of the impeachment, that the House Judiciary Committee had a different leader than it otherwise would have had.
I just also like the story of how you changed your whole strategy when you heard.
Oh, there's a judicial complexity here. At the same time, we were fighting to preserve Holtzman's victory against Sella. She won by 600 votes against Sella. There was another case going on at the same time. Alla Lowenstein, who was a prominent liberal Democrat, political reformer, on the same political side as Holtzman. He had run against a congressman named Rooney, John Rooney, and he lost by 900 votes. In other words, Rooney won by 900 votes, Holtzman won by 600 votes. Lowenstein brought a suit to try to upset the Rooney victory. So what we have here is Lowenstein trying to upset a 900 vote victory, and Sella trying to upset a 600 vote victory. So even though we were on the same side politically, we're on the opposite sides legally. I'm making the claim in the Holtzman case, basically, that you can't upset elections unless there's overwhelming proof. You just can't. You know, this is all nonsense about irregularities and things like that. And that was the thrust of my brief, in effect, and the thrust of my witnesses. I called a statistician from Columbia Law School to point out that the odds of the election would have changed because of certain alleged irregularities were greater than all the grains of sand on all the beaches of the earth. I mean, I had all sorts of testimony like that. So I'm saying you can never overturn elections, although in certain circumstances you can. And Lowenstein's arguing you can overturn elections. Because he's arguing against Rooney. So we had different sides legally, although we're on the same side politically, you know. So I win in the lower court, but for Holtzman wins in the lower court, and Rooney wins in the lower court. The election's not set aside. Then we go to the appellate division, and the appellate division sustains the decision below. The Holtzman election is not set aside. The Holtzman victory is not set aside, and the Rooney victory is not set aside. So that's in the appellate division. That's the second level of it. Then we go to the Court of Appeals, which is the highest court in the state. And I think I'm sort of home now. You know, I mean, I won in the court, which is most political below. I won in the appellate division, which is not that political, but, you know, now I'm in the Court of Appeals, which should be the least political court under the circumstances here. And at the same time, I'm winning, Rooney's winning, and Lowenstein's losing too, which I sort of expected, you know, if I could win. So I'm now in the Court of Appeals. And we're sitting there to argue in the Court of Appeals this major case, although I'm fairly confident. And I have an argument planned out, obviously, along the lines I argued earlier before. But the first case they hear is the Lowenstein-Rooney case. And Lowenstein's lawyer gets up to argue that the election should be set aside, which is contrary to the position I'm going to take in the next case. And he's treated sort of very nicely by the Court of Appeals. And then Rooney's lawyer gets up, says you can't set aside elections, making similar kind of arguments to the kind I made. It's a different case. And the Court of Appeals is all over him, really questioning him very hard, and, you know, and saying, why can't they do this? And wasn't there this error and that error? Now, it's true that Rooney was the organization candidate, and Lowenstein was, but nonetheless, they really say, oh, no, we could set aside the election. You know, that's sort of the thrust of some of the questions. He's getting a really hard time. And I realize, you know, that if they may go in that direction, in that case, in which there's a 900 vote victory, what will they do in my case was there's only a 600 vote victory. So sitting there, and this is what you're alluding to, I realize I have to throw out my whole argument. And I start writing notes to myself, and I get up. And the first thing I say is, you just heard that case, in which you discussed whether you should set aside that 900 vote victory. Now you're hearing my case, which is a 600 vote victory. My case is not that case. There are 12 differences between my case and that case. And I start listing all one after another. And one of the main differences was we were, of course, the insurgents, the reform, you know, and Rooney was, the machine was behind Rooney. But I listed, you know, that happened in this case, didn't happen in my case. So I started listing so I started distinguishing ourselves from the other case, fearing that we would be dragged down because of their attitude in the other case. And the Court of Appeals also gave me a tough time. I didn't get a tough time in the appellate division, but I got a tough time in the Court of Appeals. And then I sat down, and I didn't know what the result was going to be. I mean, I was questioned, I fought back, and the way Rooney's lawyer was questioned. And then we went back to the hotel to wait the decisions. In those cases, decisions come down right away because the elections take place shortly thereafter. Or if you had another election, it would have to take place shortly thereafter. And about 5 hours later, we're sitting in a hotel, the decision came down. The Rooney victory was upset. The 900 vote victory was upset by a vote of 4-3. And the Holtzman victory, the Holtzman 600 victory, was sustained. We won by a vote of 5-2. There were 2 dissents, the first judges that dissented. And that was, in the circumstances, it's an amazing thing that we could sustain a 900 vote victory, a 600 vote victory, and Rooney could not sustain a 900 vote victory. Now, there were differences in the cases, as I argued to the Court of Appeals. And that had this great result, that Holtzman went up to Congress, and Sella was no longer chairman of the House Judiciary Committee, and the rest is history.
How do you get hired by John Doe?
How do I get hired by John Doe? I got to go back even before being hired by John Doe. As I said, I was an assistant U.S. attorney, and I also said I went to Harvard Law School, and I met a lot of people, obviously, at Harvard, who I knew very well. One of whom was Archie Cox, who was my professor at agency, and Phil Hyman, who was a contemporary of mine in law school. He was a year ahead of me. He was in Scalia's class. And I get a call from the special counsel, the independent counsel, the special prosecutor, which had been appointed as a result of Watergate. This is prior to the impeachment proceedings, prior to any impeachment proceedings. This, of course, the special counsel, Archie Cox, is ultimately fired, and that results in the firestorm that causes the House Judiciary Committee impeachment inquiry. So I get a call 6, 7, 8, 9 months before from Phil Hyman, I think I got the call, some senior member of the staff who I knew because I knew them from law school. And they called to ask me to come down to consider joining their staff, to leaving my law firm and joining the staff as a prosecutor on the independent counsel staff, the special prosecutor staff. And I turned it down on the phone. I'm now a partner in a law firm. I have a wife and children. I'm doing fairly well. I live in the suburbs. I'm working very hard. And I don't want to be a prosecutor again. At this point in my life, I've been there, done that kind of thing. And I tell them that on the phone. And I just turn it down, turn down an opportunity to join that staff. And, I was interested. Obviously, it's a significant thing. The special prosecutor was appointed, but it's an institution I'm not a fan of. As later on, although I thought it did a great job in that thing, and it was proper to have it in that situation. So I turned it down. Then, of course, some time goes by, and Cox is fired in the Saturday Night Massacre, the famous Saturday Night Massacre. And then the House Judiciary Committee starts indicating that it's going to conduct an impeachment inquiry regarding President Nixon. And they appoint John Doe as chief counsel. They're going to set up a special staff. They're not going to use their regular staff. They can appoint him as chief counsel. So John Doe calls me. I get a call from John Doe asking me, this is how I remember it, asking me if I would come down and meet with him because he would like me to join his staff. He wants to meet me first. And I say no on the telephone. I say, well, I got a similar call months ago. I didn't say it, I don't know if I said that to him, but this was what was in my mind. I said, no, I'm not, here, I'm really not prepared to leave. I understood this was no longer a prosecutor thing. This is the House Judiciary Committee, so I sort of turned it down. The next day, I get a call from Robin Morgenthau. Now, my old boss, who now happens to be at my firm, he just, in '92, he retired as district attorney, as now is sort of counsel to our law firm in New York. But this is 50 years after he hired me. He's now at our firm. But this is 1974 I'm talking about. 1973, actually. Late 1973 I'm talking about. The Saturday Night Massacre was October '73. So this was after that, a month after that, November 1973, early December 1973. So Morgenthau calls me. Now, I don't know Morgenthau. I know him fairly well from Morgenthau is a guy who was a wonderful U.S. attorney, a wonderful district attorney, great man, but thinks the only job in the world worth having is working for him. Well, a lot of people are like that, So, and I know that. So it's because he tries to get people to work for him, and he got very good people to work for him. He had great staffs. That's what made him. That's why he's had such a great career. So he calls me up the next day. He says, I was just talking to John Doe, and I recommended you for this thing, as did some other people, to Doe. He said, Doe told me you weren't interested. I think you should think about this. And this sort of shocked me because I never thought Morgenthau would ever recommend anybody working for anybody else other than Morgenthau. No, it wasn't working for Morgenthau. I really think you should think about this. And then he said something that I never forgot. He said, you got to think about this in two different ways. And I think it may make it more attractive to you. Number one, this is an impeachment. This is history. And how often do you get a chance to participate in an event, an historical event? And number two, just as important, it's short. How long can you keep a president hanging? So you're not going to be gone for so long. You're not going to be, this is not a career thing. You're not going to be gone for years, I can understand not going to a prosecutor's office, It's history and it's short. Now, Doe's going to call you again, or somebody's going to call you again, and I really think you should consider that. I hung up the phone and I really thought about that, and it really struck me that he was right. It was history and it was short. Now, my partners weren't very happy. This firm was not all that big at the time. We were pretty successful, but I did get a call, and I agreed immediately to go down and see Doe. And I went down to Washington and I met with Doe, and he was very attractive, and we talked about how this thing would proceed, and it sounded very important and very exciting, a real challenge to a lawyer. And then I went back and I was enthusiastic about it. Once I met him, it was a foregone conclusion I wanted to do it. So I went back and I talked to my wife, who was wonderful. I mean, we had 3 little children. One was 8, one was 5, one was 2, and I was going to go off now on this thing, which was going to be hard for us, and it turned out to be hard. That was a tough year. in a family sense. I was away a lot that year. It was a very hard year, but it worked out. And then I had to talk to my partners, who most of them were understanding. There was only a few partners. They thought I was sort of crazy to go off, and I resigned from my firm because this was a very sensitive thing. My firm was not as well known as it is today. It was not as strong as it is today. It was successful, was not. So I resigned. Some people who came to the impeachment didn't have to resign, but I resigned because I felt if things went badly on this impeachment, and they could go badly, and who knows what kind of attacks we would be under, and I knew there would be attacks, and there were attacks to some extent. I just didn't want it to hurt the firm. And I wasn't even guaranteed I could come back to the firm under that circumstance. But I said I just wanted to do this. This was a great challenge. My wife was supportive, although it turned out to be a hard year. She said, and I went and I did it. And my partners were understanding too, even though they were reluctant to see me do this. But I did it. So I went down and I did it, and that's how I got hired.
Did you recruit any of the staff?
I was involved in sort of vetting and discussing with certain people, such as Evan Davis, for example. And I was supportive of hiring certain people who sort of came along. I tried to induce him to hire certain additional people, which he decided he didn't really want to do. Actually, people who turned out to be very prominent later on. One is Pierre Laval, who's now in the Second Circuit, and the other is Tony Sifton, who became Chief Judge of the Eastern District of New York. They're both federal judges. Sifton unfortunately died a few years ago. Laval is still alive and still a judge on the Second Circuit. But Doe decided, I don't want to overstate this, I wanted more litigators. I wanted more trial lawyers for this thing. I envisioned a trial in the Senate. I wanted guys who my contemporaries. Doe, he had me, and he had some other people. He had Joe Woods, he had Dick Cates. He felt he had enough people along those lines, and therefore he passed up the opportunity to hire Laval and to hire Sifton, but somehow their careers managed to do okay without coming down to our staff. So I did try to get him to do that. He was more comfortable with the staff that he sort of put together, and so a lot of the younger people we had, such as Hillary Rodham, and Maureen, who was not a lawyer at the time, and it worked out. I mean, his comfort level was important. He had me. I was sort of both very useful to him and an irritant at the same time. But I was very aggressive. I was 37 years old. I was a trial lawyer. I'd been a trial lawyer, and we had disputes from time to time as to how things should happen, and how things should proceed. When I think back, he was right most of the time, and I was wrong most of the time. He wanted to be. He understood that we couldn't come off as prosecutorial. He understood. This is very important. He really understood, and Rodino did too. I understood it to some extent, but less so. I understood what he was saying, and I sort of agreed with what he was saying, but I still wanted to be more aggressive in terms of the investigation. He was very cautious about how we should investigate this thing. He understood that the papers would be writing if we sent out investigators. He basically wanted to do it in a low-key fashion, have the information collated from various sources, especially the special prosecutor who ended up giving us a sort of a report, some sort of roadmap, so to speak, although it wasn't, and then of course we got the tapes. We didn't do a lot of original investigation. We did some, but not very much. We interviewed the witnesses, obviously, before John Dean and John Mitchell and people like that, but we didn't go out to aggressively investigate the facts, which is something I wanted to do. I felt we had to do. This is my background, but as a prosecutor, as a private lawyer, Doe was much more cautious about doing it, knowing that we send people out, there'll be newspaper stories, people, who knows what we'll get, who knows how we'll be attacked. So he was to just take it step by step. Other people were gathering information, or information was coming in. Let's just put it together. Let's just collate it, and we'll present it in a neutral fashion. That judgment, some of which I opposed at the time, I realized after it was all over, happened to be a correct judgment. And I think it was very helpful in achieving what was the ultimate outcome. At the beginning, we weren't sure. I wasn't sure, at least. And I don't think Doe was sure either, although articles have been written contrary to this, that we were going to recommend the impeachment of the president. That wasn't, we didn't come in and this is how I remember it, and I truly believe this. We weren't coming to drive him out of office. We were going to see what the facts really were. Obviously, we were suspicious about the events that led to the Saturday Night Massacre, and and the president's conduct and the conduct of some of his chief aides, but there was no real, no real animus, no real desire to say we're gonna try to get President Nixon out of office. Even look at what I just said, Nixon, I said, but really it's President Nixon. Doe, and we all remember this, Doe charged us all with never calling the president other than by the name the president, not Nixon, and certainly not anything, derogatory. We had to call him, he was the president. We called him the president. We were trained to call him the president, and he was, and that's a very interesting insight. He understood that. Something I don't think I might not have understood at the time, but of course, we understood. We called it Nixon. We tried to treat it with respect, and we wanted to aggressively find the facts, but as I said before, we didn't really go out and investigate on our own, but collate the facts. And also when we started collating the facts and gathering the facts, and especially, of course, when the tapes came, then we did make a determination that the proper recommendation to the committee would be to impeach the president. But we didn't start off like that. People claim we did. So, and a friend of Doe's wrote an article, Renato Adler sort of claims that he always intended to do this. I never saw that, and I don't think it's true. I think Doe also sort of had an open mind until the facts sort of came in together, and then at some point they gelled, and we made the decision, especially after the tapes came in, that we really have to go all out to try to convince the committee that the right thing to do would be to impeach the president.
Tell us a little bit about how Mr. Doe took advice when you were having this discussion with him, and I'm sure it happened more than once. Was Joe Woods also part of that discussion,
Yes.
whether or not to continue the investigation started by the Senate?
Yes. No, Joe Woods was an old, very sensible person. Doe surrounded himself with good people. He used different people in different ways, and he consulted with them. He was fairly close to the vest at times. He didn't really know me before, and we, as I said, we had a good relationship, but a rocky relationship to begin with, but it had ups and downs. But over time, I think it became pretty good and pretty close, which I think exists today. We were different personalities. He was more of a Midwestern type. I was sort of an aggressive, East Coast prosecutor, I guess. But he relied on other people too. He relied on Woods, who's a good example, who was a very common sense guy, also a cautious person. He relied on Dick Cates, who was more of a trial lawyer, and I related to him very, very well. But he liked Cates a lot. He used Cates a great deal to interface, that word I don't like, to be a contact with the committee itself. So Doe, and he was comfortable with the younger people. He was comfortable with Hillary. He was comfortable with Evan Davis, who was about 30 years old at the time. We had Bob Sack, who was a few years younger than me, who came in. We had all sorts of good people, sensible people. He put together a good staff, partly through his Burke Marshall, who was also a key advisor. He had sort of a kitchen cabinet, in effect, who he looked to. Burke Marshall, Owen Fiss, Bob Owen, then Joe Woods and Dick Cates, who were on the staff. Some were on the staff, some weren't on the staff. So Doe sort of reached out. He knew he was in a very sensitive situation, and when I think back, it was handled, as well as anybody could handle it.
Would you and Woods participate in discussions with the kitchen cabinet?
Sometimes yes, and sometimes no. Not always. Sometimes, Doe was always in contact with various people on his own. There was no formal meetings a lot, but sometimes I would talk to Marshall myself, who was really a key figure in the kitchen cabinet. And Burke Marshall was also a key figure in recruiting people for the staff. Hillary, I think, came in through Burke Marshall. Mike Conway came in through Burke Marshall. various people came in through Burke, and the Yale connection. Bill and Hillary Clinton obviously went to Yale. Well, she wasn't Hillary Clinton then, she was Hillary Rodham then. So Burke was a key figure both in recruiting people and advising Doe. And Burke was a very sensible guy. He was a great assistant attorney general in charge of the Civil Rights Division prior to Doe having that position. I met Burke Marshall actually, I worked in the summer of 1960. I graduated law school in '61. So I think I met Burke Marshall 14 years before, when I was just a kid, before I graduated law school, even when I worked in Covington and Burling for the summer. And Burke Marshall was then a partner at Covington and Burling. That was during the year of that Kennedy was running for president. This was 1960. Kennedy hadn't yet been elected. I worked the summer of 1960. Kennedy was elected in November of 1960. And I knew I knew Burke slightly. He was a partner, a young partner. I was a second summer associate. But I had a great respect for him, and he was a wonderful assistant attorney general. I knew from my Justice Department days, because I was in the Justice Department the same time he was. I was in the U.S. Attorney's Office in New York. He was in Washington. But I knew of him then, and he was a wonderful advisor, I think, to Doe. And I kept in touch. I met him from time to time over the years after the impeachment, normally at Doe's farm, and he was just a good guy. He's also dead now. He just died a few years ago. A wonderful guy.
Can you remember some of the effects that his influence had?
No, not specifically. I just thought he generally was cautious, and he gave good advice. You know, I don't remember any particular issue at this point. I mean, I think Doe consulted him on a lot of things, virtually anything. The key person to interview here is Doe, but and he can tell you much more, obviously, because he's still, I don't know if he's going strong, but he's still, but he relied on Burke a great deal on the end, and that was good. It was I just wanted to do our job. I wanted to get the facts. I wanted to present the facts. My job on the impeachment, I was a very senior person on the impeachment, obviously. Joe Woods and I and a few other, nobody was really sort of number two. There were a number of number twos in effect for different purposes. Joe Woods might have been, but he only didn't stay the whole time. I was there the whole time. Cates, there's no deputy chief counsel, at least the way I remember it. My title was senior associate special counsel, and I had the highest salary anybody could get, $36,000 a year at the time. That thing was a little less than I was making, a lot less than I was making as a partner in my law firm, which I just resigned from with 3 children. But so different people sort of had different tasks, and my basic task, ultimately, as a very senior aide to Doe, was to sort of oversee the factual investigations. We set up various task forces at the time, as I remember. Others who you've interviewed, of course, could be more specific. And there was the Watergate Task Force, which Evan, I think, worked on. There was the Agency Task Force, which Bob Sack worked on. We had people in charge of legal research and writing. John Labowitz was sort of a leading figure there, and we divided people among these various task forces. I was sort of over all the task forces, in effect. They didn't sort of directly report to me. It was not all that hierarchical. You know, I was sort of in charge, in my mind, of the factual investigation. I would work with each of the task forces to some extent. And then when the tapes came in, later on, I was sort of in overall charge, at least as I remember it. I don't know, other people can remember it differently, but I do remember it, in dealing with the tapes, in having the tapes transcribed, analyzing the tapes, and deciding how we could use the tapes. So that was sort of my role. And then I was going to be, not in charge is too strong a term, as if I'm the only person. I'm not the only person, but I'm one of the key people, because there wasn't a lot of trial lawyers there. So then I was going to be in charge. Again, I use that word. You can't. I was going to have a very important role. Let me put it like that, in planning the trial in the Senate. You know, that's what I was really. I was convinced that President Nixon, would never resign, even and that we would have to try this case in the Senate. So I was always thinking, how do I try, as I do in private practice when I have a case, or I did in the U.S. Attorney's Office when I was a prosecutor. How do we try this case? Who are we going to call? Who are our witnesses? What are our documents? What are our themes? You know, this is the kind of thing we did. My other function, in connection with that, I was tasked to make a key presentation to the committee on the necessity for a third article in the article of impeachment, which involved our inability to get tapes and documents directly from the White House. The tapes we got, obviously, were from the special prosecutor who received them as a result of litigation against the president in the Supreme Court. They refused to turn over many documents and tapes to us, and under my leadership here, we claimed that was in itself an impeachable offense, not to cooperate with the committee. And we had law going back to the mid-1800s to support that. That was a very important position. I took a very strong position, which Doe basically agreed with mostly, that we're not going to go to court to try to get documents or tapes. That the courts had no role in this process. That the Constitution set up the impeachment process. If there was a basis to try to impeach a president, that was a congressional prerogative. When Congress started a legitimate impeachment inquiry, it was entitled to reach into the dark recesses of the administration to get whatever documents and tapes or whatever existed to help it formulate a decision with respect to impeachment. And if the executive branch and the president refused to cooperate, that itself was an impeachable offense. That was contrary to the Constitution, that undermined the constitutional scheme. So we didn't go to court. We didn't bring a case in court. Now, the recent Clinton impeachment, proceeded differently, but that was a phony impeachment. That was a political impeachment. This was as Hillary once said to me, the only constitutional impeachment was the one we did in 1974. But so one of my key roles was to be involved and in charge of, to some extent, with factual gathering, and that meant trying to deal with the White House to get these things. And when they didn't give us a lot of this stuff, which I thought undermined our ability to present a proper case to the House Judiciary Committee, that itself turned into an impeachable offense, I thought. We drafted an article, which I was involved in drafting, and then I was also involved in making the presentation to the committee in support of voting out that article of impeachment, and it was voted out. It was a third article of impeachment. Indeed, in my mind, I always thought about it then, and I still think about it now. It's still a key historical precedent and constitutional precedent in the event of any future impeachments, which I hope none really come up, that the executive branch is obligated to cooperate if there really is a legitimate impeachment inquiry.
But what happens to so you believe that then the concept of executive privilege has to be completely waived then by the White House?
In an impeachment inquiry, yes. Not in any other inquiry, but in an impeachment inquiry, yes. Not in a criminal case or not in any other case. But the executive privilege falls in an impeachment inquiry, and that's the only place it falls. That's what I believe.
Okay.
That's not the way it worked out in Watergate, and it hasn't worked out since. In Watergate, it happens, the Supreme Court, as we've discussed, the Supreme Court decided that there is such a thing as executive privilege, but it can be overridden by the needs of a criminal case. That resulted in them ordering the tapes to be turned over. President Nixon then turned over the tapes, and then the tapes were then sent to us by the special prosecutor.
But
that's a different...
But I was going to ask you, if the impeachment proceedings involves a crime by the president, are you not then asking the president also to waive his Fifth or her Fifth Amendment rights?
The impeachment proceeding is not a criminal proceeding. The impeachment proceeding doesn't send anybody to jail. The impeachment proceeding to decide whether somebody should stay in office, or it's fit to stay in office. And in that proceeding, if the president takes the Fifth Amendment, you can use, or refuses to testify, because then he might be subject to a criminal proceeding, then you can take that into consideration, in effect, in deciding he's not fit to stay in office. It's a whole different thing. And that's the whole, and also, we had big discussions about this, and other people can discuss this as well or better than I. You know, to impeach a president, you don't have to prove that he committed a crime. This was a major discussion. It doesn't have to be a felony. A high crimes and misdemeanors has a different meaning on our Constitution, we thought, the word crime or misdemeanor normally has. It had to be something that only a president can do that undermines our constitutional structure, that's an abuse of power, whether it turns out to be criminal or not. That was a very interesting discussion at the time. And the misuse of the FBI to investigate your political opponents may or may not be a crime, but that's an impeachable offense. The misuse of the CIA, whether or not it turns out to be a crime, is an impeachable offense. When you send the CIA to act outside its proper parameters for your own political interests, that's a crime. That's rather an impeachable offense. It may not be a crime. That's an impeachable offense. Those are the issues we try to deal with at the time, and that's what we try to articulate at the time.
Well, it's articulated in that document, the grounds for
impeachment, right?
Can you tell us what you remember of who was on which side in that debate?
No, I don't think, others may have different memories, and it's been a long time, obviously. I don't think we had different sides so much in the debate. I think we all reached a conclusion. I know I reached that conclusion, but I think there's not a lot of opposition to this. The more we looked into it, the more we realized that what we really were investigating was not whether the president committed a crime, and we didn't have to, but whether there was an abuse of power by the executive branch and by the president with respect to the Watergate matter. And that's all we really needed to show, ultimately. Whether we had to do that. And I don't think there was a lot of conflict on the staff. It took time to reach that position because this was all new. There hadn't been an impeachment of a president in 100 and some odd years. The last one was Andrew Johnson. That was clearly a political thing over this act, which Congress passed, saying he couldn't fire the Secretary of War. It was a much more confined, much more narrow thing, and he almost was impeached over that. It's true Congress can impeach a president for anything it wants to impeach a president, but the proper way of looking at it is to see whether or not there was a fundamental abuse of power by the executive branch, contrary to our structure of government, contrary to our constitutional principles. And that's what we concluded. I don't think there were people on different sides of that. Maybe some people at the beginning said, no, we really have to prove some sort of crime, but I don't remember anybody pushing that hard. Labowitz, I think, was one of the key people who wrote that memo, the grounds for impeachment memo, and I think Hillary helped on it too, on that memo. But that's the conclusion we reached at the time, and I think that's the conclusion that's still correct.
Since you oversaw as much as a kibitzer as a supervisor the task forces, tell us how you came to conclude how to present the information to the committee, because you had an enormous amount of information.
Yeah. Well, this was, I give most of the credits, not to myself, because I don't deserve the credit, but to Doe. This is an interesting problem. Doe, well, look, the thing really took off after we got the tapes. We realized the stuff on the tapes was very powerful. And of course you had the 18-minute gap, and you had all those issues. Doe was the one who decided that we're going to present this in a sort of low-key, neutral fashion, these sort of statements of facts, whatever we call them at the time. I haven't refreshed myself on this. And these books that were given with listing fact after fact after fact, statements of information. That's what they were called. I still have those books, Statements of Information. I think it was called Statements of Information. Not even facts. It was interesting. We didn't want to, shows how cautious John was. We didn't want to say they were facts. They were information. So we present this information in the form of a sheet of paper, which was read to the committee, and behind it was documents demonstrating where we came up with this statement of information, not statement of facts. Gee, I remember that. I said, why can't we call it a statement of facts? But because that was, if you say it's a fact, you're sort of making a judgment that something happened. If you say it's a statement of information, you're just presenting some data which somebody else could make a judgment as to whether it's accurate or factual or not. So statements of information, it even shows how careful this thing was thought out by But I give all the credit here to John. This is not the normal way you present to a grand jury, but he did it like that. And so he came up with a scheme. I was, I think, dubious at the time whether this is the most effective way of doing it. Indeed, it was kind of boring to the committee. You, as a trial lawyer and as an investigator too, because I conducted grand jury investigations in my time, you sort of want to, spice it up a little bit. You want to make it interesting. But Doe wanted it to be boring almost, which is right, which was the right decision. It's counterintuitive, but it was right. So they'd sit this committee, and Evan Davis would read from a statement of information. On June 18th this happened, on July 3rd this happened, and this document, or this piece of grand jury testimony, which we got, or this tape, or back that up, and he wanted it to have some sort of cumulative effect. I think without the tapes, it would have fallen flat. But then we had the tapes. And then also finally they called witnesses. Finally we did have witnesses testify. And then I was actively involved in the witness preparation, which is more my métier, I prepared John Dean, who I must admit turned out to be sort of the perfect Nazi corporal, in the sense that whoever was in power, he would sort of, I'll tell a Dean story, which is interesting. I sat with John Dean for 4 or 5 days, preparing him to testify before the House Judiciary Committee. And he's very intelligent, and he was very smart, and he was very knowledgeable about what happened. He was a key witness before the Senate Watergate Committee. And so I'm preparing him for his testimony. And of course there are gaps, like everybody, you're trying to sort of figure out. So I'd play the tapes with him. We'd listen to the tapes, and then I'm trying to figure out what happened between, let's say, incident 1 and incident 2, or day 1 and day 2. And like I normally would do with a witness sometimes, we would try to sort of logically figure out what would have happened. To sort of connect certain things, but I didn't know for sure. And sometimes I would start making suggestions. Well, isn't the most logical thing that happened this? Since this happened here and that happened there, isn't the most logical thing that happened between this? And all of a sudden, I start seeing Dean start agreeing with every logical hypothesis that I would put forward, even because he wanted to go along with me. I really didn't want him to go along. I just wanted to try to figure out what happened. But I realized he was going to go along. So I got very cautious because I didn't want to put words in his mouth, and I didn't want to make things up, and I didn't want to create facts that weren't facts. Now some prosecutors do that, and as I've learned over my career, I didn't really want to. But Dean was sort of, he's perfectly willing to sort of accept my hypothesis, so I became, somewhat cautious about it. And then I realized, listening to the tapes, listening to Dean on the tapes with President Nixon, that Nixon would be doing the same thing with him. So he would start going along with President Nixon, and Nixon would, oh, that didn't happen, John, or this happened, and sure enough, Dean would start folding on the tape. He was sort of being directed by Nixon. Nixon was trying at this stage to sort of direct him into to thinking in a certain way and to go into a certain fashion. And then I found when I was talking to Dean, that the same thing was happening again, except I was in sort of, quote, the position of power. I represented the House of Representatives, not me personally. I was, so he was like going along with me, just like he was going along with President Nixon. I was very cautious. I'm not. Having said that, I'm not saying he lied or he may think. I think he was just willing to bend very. So we were careful. Anyway, he testified before the committee, but the committee testimony turned out to be somewhat anticlimactic. I mean, James St. Clair, the president's trial lawyer, who was a good lawyer, who I got to know during the hearing, cross-examined. But really, the truth is, the witness didn't have a great impact. John Dean's testimony didn't secure President Nixon's impeachment, or John Mitchell. remember John Mitchell. John Mitchell was a tough guy. He wouldn't talk. He was. I tried to break him down. Dean, it was easy. Mitchell, he was tough. Friends of mine in New York had represented him in the criminal case. Guys who in the U.S. Attorney's Office with me ended up as defense lawyers, and they ended up representing him. He was a tough guy. Mitchell, he wouldn't give an inch, in effect. I guess he testified before the committee too, but he didn't get. Dean testified similar to the way he testified, obviously, before the Senate Watergate committee. But the testimony. Everybody said, we gotta have witnesses, we gotta have witnesses, we gotta have witnesses. I said it in the early stages. It turned out Doe's instinct, as I remember, it was the right instinct. The witnesses, well, yeah, fine, we had witnesses. We had to satisfy the committee. If it was up to Doe, we wouldn't have witnesses, I don't think. He didn't want witnesses, but the pressure of the committee was we had to have some witnesses, so Doe said we have to have some witnesses. It was my job then to prepare these witnesses, to be me and others to prepare these witnesses. And the witnesses, which I had great hopes would be, had great impact, really didn't have great impact. What had great impact was these statements of information, one after another, which were boring, plus the tapes. The tapes, once you heard the tapes, and you could put the tapes together with documents and with some of the testimony, that created this tremendous impetus for impeachment.
Tell us about, please, the first time you heard the tapes, if you can remember it.
Well, I'll tell you a story about how I heard the tapes, and I'll tell you a Hillary story in connection with this. The first time I heard the tapes by myself. It was I was one of the first people on the staff to hear the tapes. Doe, obviously, heard the tapes at the same time, and we were shocked is the wrong word. This was tremendous proof to us that really there was a significant abuse of power by the White House, which went to the very top of the White House. So it had a big impact on Doe. It had a big impact on me. That we really had a case here. Which was reflected in the articles of impeachment that we ultimately drafted to the committee. And we had them transcribed, and then I had this vivid memory of then playing with the committee for the first time. And I remember sitting there, this is a private session, obviously, when we played the tapes for the committee. Just the senior members of the staff and the committee were there. And everybody in the committee had their earphones on, listening to tapes, but I didn't have my earphones on. I heard the tapes. I wanted to just watch the committee. And I've never forgotten this. I saw this committee. I saw, especially the Republicans, the people, we would desperately try to make this nonpartisan, to reach over to the other side if we recommended impeachment. And after we had the tapes, we knew we were going to recommend impeachment. And I saw the faces of the members like flush, get red, the Republicans. They acted very disturbed when they were listening to the tapes. And I sat there, I said, they realized that this is something we have to do. I said to myself, as I was sitting there, just watching the committee, in the committee room, in this private session. And I remember the session ended, and I remember everybody taking off their earphones, and they're just walking out, and I was really pleased to see that it had that impact. A day or two later, we have another meeting with the committee to discuss the tapes, to discuss what we heard. And we're going to lead the discussion, engage with them, Doe. And all of a sudden, they came in, and I started hearing rationalizations. Oh, well, he really didn't mean that. He didn't really say that. I mean, this was just hypothetical. All of a sudden, you saw them trying to escape the language of the tapes. I mean, in the 24 or 48 or 72 hours that had passed since they heard the tapes, they came in with all sorts of rationalizations. And now, of course, we answered some of that with other things, and this friendly discussion. I mean, we were the staff, they were the committee, but I feel, oh my God, this is going to be a tough sell. I said, so I was really concerned about how this thing was going to come out at the time. And then, since this is a Hillary story, then sort of that evening, or an evening just at about that time, I had a big Oldsmobile Toronado, Remember, I was a partner of a law firm. I resigned, but I still was in a better economic position than most. I was older. I was one of the oldest people on the staff. That was another thing. It was a very young staff. I was 36 years old. I became 37 during the impeachment. I was an old man on the staff. Everybody was younger than me, other than Joe Woods and Dick Cates and John Doe. And since I had a car, and this was Washington in the 70s, and it was sort of a dangerous place, it was my job to sort of drop young staff members home off at night. I've told this story before, but it's a good story still. So I would pile people to my car at 11 o'clock, 12 o'clock at night, because we were working around the clock on this stuff, and I would just drop them off one after another, and then I would go to my little apartment that I had, you know. And so one night I'm dropping all these people off, and the last person in the car with me that night is Hillary, who I'd been working with, and Hillary Rodham, who was a star on the staff, and Doyle liked her, and I liked her. She was a hard worker, really aggressive, and really smart. So anyway, I'm driving. She's now in the car alone with me, and I'm driving to where she lives. She's living with a woman named Sarah Ehrman, who ended up in the White House later on with me. In any case, I'm about to drive. I'm sort of pulling up to a place, not quite there yet. And she says to me, "Oh, I want you to meet my boyfriend. He's coming in tomorrow," something like that. I said, "Oh, great." I said, "What's his name?" And she said, "Bill Clinton. I met him, in law school. We've been going out." And I said, I didn't know. I wasn't paying attention to people's personal lives at the time. I was so driven, at that point. I didn't know she had a boyfriend even. She said, "No, you got to meet Bill Clinton." I said, "Oh, that's great. I'd be happy to meet him. I liked Hillary a lot. I'd be happy to meet him." She said, "Yeah." I said, "You just graduated? What firm is he going to?" Or something like that. And she said, "Oh no, he's not going to a firm. He's going going into politics, and he's going to be the senator from Arkansas. He's from Arkansas. He'll be a senator from Arkansas, and he's or the governor or something from Arkansas, and he's going to be president of the United States." And I look at this woman, this 26-year-old woman, and I say, I remember this to this day. I say, what have I gotten myself into? I am now a senior person on the staff. I'm sort of in charge of the tapes. I presented these tapes to the committee. Now, these tapes are devastating evidence with respect to the impeachment. The committee hears it, it realizes it, and then it comes back later and it's starting to rationalize them away. We're not going to be able to make the case. We're going to look upon as the dumbest lawyers in history, not being able to make a case at this thing. And Doe refuses to hire people that I want down here, such as Pierre Laval and Tony Sifton, real trial lawyers who could help me make this case. He hires a bunch of kids who are bright kids. One of these kids is now sitting next to me. There's a young woman who I like a lot, is very bright, but never really tried a case or anything. And now she's telling me her boyfriend's going to be president of the United States. I said, "This is nuts." So I blow up. I start screaming at her. I said, "That's idiotic." I said, "That's the stupidest thing I ever heard." I said, "What kind of child are you that you're going to be president of the United States?" I started screaming. I guess all this frustration away from home, the tapes, the committee, not hiring certain people, I start screaming at her because she tells me her boyfriend's going to be president. I said, "I'm working with a bunch of children, children here, and I can see." And she looks at me. She glares. We pull up to this place. I still remember this. She looks at me. She glares at me. She says to me, she gets really mad. She said, "You're an asshole," she says to me. "You don't know what the fuck you're talking about." She says, "This guy is great, and you haven't even met him, and you're just a big jerk or something." And she opens the door and slams the door and storms out of my car and goes into a place. And I'm sitting there. I'm sort of blaming myself. I said, "What did I do?" She says her boyfriend's going to be president. What do I, why should I get so upset about it? Because, so, God, I was very upset. So the next day I go into the office, and the first thing I do is seek her out to apologize. I wouldn't even apologize to her, even though I was her superior, so to speak, because I screamed at her. I started to screaming at her. And before I could apologize to her, she comes to see me to apologize to me for saying it. So we apologize to each other. We make up, immediately. And then, well, sure enough, she brings in this tall, good-looking guy who I never met, named Bill Clinton. And he comes in, and I chat with him for a little while, 5 minutes. I mean, I'm very busy. He tells me, I don't say anything. He tells me he's going to run for Congress or something that year. I said, oh, good luck. And, I don't want to start any more fights with Clinton, Bill Clinton, or Hillary Rodham, his girlfriend. And he, we agreed, and then it's the last I see of him, at that particular point in time. Of course, as time goes on, at the end of the impeachment, after President Nixon resigns, she tells me she's going to Arkansas. I'm trying to talk her out of going to Arkansas. A nice guy. I'm not telling her what to do with her romantic life, but I really think she should go to New York or Washington to a big firm. No, she's going to go to Arkansas to live with Bill Clinton. I said, oh, all right. She's going to go. And sure enough, she goes, and we stay in touch with each other, and he runs for Congress that year in 1974, and he loses, but not by very much. He ran against a guy who was in office for 8 terms or something like that. He loses by 4 or 5 percentage points. A really very good race. He's 27 years old at the time. And the next year, I get a letter from her saying he's running for Attorney General of Arkansas. And when I sent a contribution, I'm not going to fight with Hillary anymore, so I sent in a contribution right away. I said, I'm back at my law firm, so I have money now. So I sent in a contribution, and sure enough, he wins as Attorney General. And 2 years later, 1980, I think it was, he runs for governor, and she gets in touch with me and asks me to contribute, to help, so I do a little bit. I'm busy. And actually, I was in touch with her over the years also, because she's at the Rose Law Firm, and my firm was using that firm or working with that firm on certain major matters. So I'm sort of in touch with her, not very much, but so I think I contribute to the 1980 race. And of course, he's elected governor. And I'm thinking, oh my God, see, well, what she said, but this is crazy, I said. And she invites me to the inauguration in Arkansas, but I can't go because I'm in the middle of some big trial at the time. So I never went to a gubernatorial law, so I didn't go. And 2 years later, he runs for governor again in 1982, and he loses. I say, see, I always knew I was right. He should have gone to a law firm. And he runs for governor 2 years after that, and he wins. And the rest is sort of history. I get involved with him. When he's running for president, she calls me in 1988, says she comes into New York to see me in 1988.
Bernie, let's stop for a moment and change.